Hello, I'm Rebekah Batt, a barrister at Pump Court Chambers. Welcome to this webinar, during which I will cover small claims and the new pre-action protocol for personal injury claims below the small claims limit in road traffic accidents. I should start at the outset by saying that I could speak for 2 hours on each of those topics at least. So this webinar will just cover some of the key points for each area, and it's in no way a substitute in particular for reading the new pre-action protocol in full. Turning firstly then to small claims in general. So first things first, which sort of claims will be allocated to the small claims track? The case will be allocated based on value. So where the value of the claim is less than £10,000 in total, it's likely that it will be allocated to the small claims track, but it also provides for the value of personal injuries. So where the value of personal injuries are less than £5,000 and arise out of a road traffic accident, then the small claims track will apply, unless the claimant is one of the people that's specified in Rule 26.6a, which includes if they are a child, a protected party, or if when the accident happened, they were riding a motorbike, they were a passenger on a motorbike, they were using a wheelchair, they were on a bicycle, riding a horse, or they were pedestrian. So essentially, anyone involved in a road traffic collision who is not an adult and was in a car at the time of the accident, in those circumstances, it's £5,000, but otherwise the value of the injuries must be less than £1,000. If the injuries arise other than from a road traffic accident, then the value of those injuries needs to be less than £1,500 for this to be the relevant track. Everything that you need to know about small claims is in Part 27 of the Civil Procedure Rules, but that part expressly disapplies several other parts of the Civil Procedure Rules. So, for example, Part 36 does not apply. So Part 36 offers do not have the same force in a small claims context as they would in fast track or multi-track cases. In addition, Part 32 in relation to evidence, apart from the court's power to control evidence, doesn't apply, and the majority of Part 35, which relates to experts, does not apply. There are a couple of others that don't apply either. So small claims are really in a world of their own in terms of the rules that apply to them. Moving on to some brief points about hearings in small claims. In terms of preliminary hearings, so on allocation to the small claims track, the court will give directions. Those directions are usually standard directions, but they can include some special directions. For example, if the court considers that oral evidence from an expert might be required. The court may hold a preliminary hearing, but only in certain circumstances. So, for example, where special directions are needed to ensure a fair hearing, or it appears necessary for one of the parties to attend court to ensure that they understand how it is that they comply with those special directions, or to enable the court to dispose of the claim on the basis that one or other of the parties has no real prospect of success, or finally, to enable the court to strike out all or part of a statement of case on the basis that it disclosed no reasonable grounds for bringing or defending the claim. The small claims track is really all about proportionality. So generally speaking, the claims will be listed straight away for a final hearing with directions up to that hearing, because it would not really be proportionate to the value of the claims to have more than one hearing, given the costs involved in those hearings. In terms of the conduct of the hearings, hearings in the small claims track are informal, and the court can adopt any method of proceeding that it considers to be fair. Strict rules of evidence do not apply, and anyone giving evidence doesn't need to give an oath beforehand. Turning to non-attendance of parties at final hearings, taking this in turn. So if the claimant does not attend and they haven't given notice to the court or the other party beforehand. So giving notice would require notice in writing at least 7 days before the hearing to the court and the other party, requesting that the court decide their claim in their absence. If they haven't done that and they don't attend at the final hearing, the court may strike out their claim. On the flip side, if the defendant does not attend and hasn't given notice 7 days before, the court may decide the claim on the basis of the evidence of the claimant alone. Importantly, both of these provisions state what the court may do. So it's not mandatory for the court to strike out a claim in the absence of the claimant or decide on the evidence of the claimant alone in the absence of a defendant. But in deciding what to do, the court will, of course, consider the overriding objective and the need, therefore, to conduct cases justly and at proportionate cost. So we're back to that proportionality again, whether it would be proportionate to have another hearing if someone hasn't attended. Lastly, in relation to small claims, costs in small claims are governed by Rule 27.14, and they're very limited in small claims. They're limited to fixed costs and court fees. Turning now to the far more exciting new protocol, also known as the RTA Small Claims Protocol. Just briefly, some of the key features of this protocol are that there is now an extensive list of definitions included within it. The protocol is designed so that it could be used by an unrepresented claimant in theory, which is at least part of the reason for the exhaustive list of definitions at the start. There is a feature which means that there is an admission by default if there's a failure to respond to a claim. So this is a very important and new point, which I'll be coming back to shortly. There are also some restrictions on withdrawals of admissions, and there's a new distinction between what's termed protocol vehicle costs and non-protocol vehicle costs, which is something else that I'll be coming back to. And finally, in terms of the key features, there's also a requirement that a search is undertaken of a database which will provide details of any previous personal injury claims brought by the claimant. So first things first, when does the new protocol apply? It applies to accidents which happened on or after the 31st of May 2021, where the claimant has suffered personal injuries, including but not limited to whiplash injuries as a result of a road traffic accident. The amount claimed for the injuries at the time of starting the claim should be less than £5,000, and the value of the overall claim is less than £10,000. Importantly, that overall value of £10,000 does not include what is referred to as non-protocol vehicle costs. So the definition of protocol and non-protocol vehicle costs is included within the protocol, but essentially protocol costs are those which have been claimed, paid, or are intended to be paid by the claimant personally. So for example, their vehicle excess or repairs to their vehicle where they intend or have already paid those themselves. Non-protocol vehicle costs are costs which would be payable by the claimant to one or more third-party organisations. So a common thing that might fall into this category are credit hire costs. So those costs would not be considered part of the overall value of the claim at the beginning when you're deciding whether or not the protocol applies. Because of that, non-protocol vehicle costs are outside of the ambit of the protocol and dealt with separately. But if the parties are unable to agree the settlement of damages for those that would fall within the protocol, within the portal, then the claimant has to inform the court about the non-protocol vehicle costs pursued at the point of starting any proceedings to determine the value. At that stage, the non-protocol vehicle cost will be added to the value of the claim, and if above £10,000, the protocol no longer applies. There are some exclusions which are at 4.3 of the protocol, which include where the duty said to have been breached is owed to a road user by a person who's not a road user, or where injuries arise at least partly because of a breach of Section 53 of the Health and Safety at Work Act, where the accident involves an untraced driver, or where the claimant is a vulnerable road user. That's again defined within the protocol, but it includes motorbike riders, passengers, people using wheelchairs, pedestrians, people riding a bike, etc. Is very similar to the list of exclusions that I went through earlier under Rule 26.6a, which applies for small claims generally. Or if the claimant is a child, the claimant is bankrupt, or the defendant's vehicle is registered outside of the UK. So once you've determined that the protocol applies to your claim, it's not true that the protocol will always apply to your claim. It can stop applying. These circumstances are dealt with at 4.5 of the protocol. They include obvious things such as if the claim is revalued and it no longer falls within those limits that I just went through. But it also ceases to apply when either the claimant or the defendant become a protected party, or if the compensator states that there is a complex issue of fact or law, or they make an allegation of fraud or fundamental dishonesty against the claimant. So in those circumstances, the protocol would cease to apply. It's also important to note that limitation is not stopped by entering a claim on the portal. So court proceedings must be started within the 3-year period, regardless of any steps being taken on the portal. So if a claim is entered on the portal and the parties are going through the motions, taking the steps provided for within the protocol, and that limitation period is looming on the horizon and the claimant considers that it will end before all the steps are completed, the claimant can start court proceedings at that stage, so issue protectively. But in doing so, they must apply to the court for a stay while the steps under the protocol are completed. Before a claim is entered on the portal, and this is something I mentioned earlier, the claimant's representative must undertake a search on what's called the Claims and Underwriting Exchange database for any previous personal injury claims made by the claimant. If the claimant isn't represented, then that search will be done automatically and a reference number will be provided. Looking then at liability within the protocol, when the small claims notification form is being completed by the claimant, the first form that needs to be completed, the claimant can upload photos, sketch plans, witness statements, dash cam or video clips in support of their assertion that the defendant is at fault for the accident. If the claim ever gets to the point where the court is required to determine liability, the court will take into account all of that evidence that was uploaded at that stage. So from the claimant's point of view, it's vital that all of the evidence that is uploaded is evidence they wish to rely upon, but also that all of the evidence that they do want to rely upon is uploaded. In particular, the protocol specifically provides that the court may decide not to allow new evidence to be produced. This is a point that I said I would return to earlier. There are some really key time limits within the liability stage of the protocol, and it's really important to note these because of the consequences of missing these deadlines within this new protocol. So once the small claims notification form is complete and it's signed with a statement of truth, it's entered onto the portal. The portal searches the motor insurance database for the compensator and sends the claim to the compensator. The compensator must then provide a response on liability within 30 days of the date that the claim is accepted on the portal. Where there is no response from the compensator within that time limit, liability is taken to have been admitted in full. So missing that time limit means liability has been admitted completely. If no compensator can be identified by the database, the claim will be sent to the MIB. And if it's being dealt with the MIB, then that time limit extends to 40 days rather than 30. But where the MIB passed the claim on to another compensator to act on their behalf, the time limit for a response is not extended. So it's always either 30 or 40 days from the date that the claim is entered on the portal. So you have to respond within those 30 or 40 days. But in terms of the options for responding on liability, there are 4 options available. You can either admit liability in full, admit it in part, deny it completely, or admit fault for the accident in full or in part, but dispute that any injury was caused in that accident. Importantly, unless liability is being admitted in full, the response must give the defendant's version of events and provide any evidence in support, in the same way as the claimant had to provide any evidence in support of their claim. That response must also have a statement of truth. If there's an admission of liability in part, the percentage that is admitted must also be included. If liability is completely denied, then as before, the claimant must start proceedings for a determination on liability. But before they do that, the claimant can challenge the denial of liability, and they're able to set out arguments in support of their challenge. There isn't a time limit provided for a response to that challenge, but the protocol states that any response should be within a reasonable period. If liability is still not agreed, then the claimant would need to start court proceedings for determination of liability. At that stage, nothing further happens under the protocol until a determination has been made. But once that determination is made, if the court finds the defendant liable in full or in part, the court will stay the proceedings and direct that the parties follow the relevant steps in the protocol for quantum to be negotiated. So you can fall out of the portal for a determination of liability and then be sent back in to negotiate on the value of the claim. That, of course, would not happen if the court determined that the value of the claim now exceeded the limits required to be under for the protocol to apply. So whereas in the previous version of the protocol, anything other than a full admission of liability would cause the claim to fall out of the portal, if there is an admission in part, the claimant may accept it or they can challenge it. Each party can then make up to 3 proposals on liability through the portal, and each proposal must be an improvement on the party's previous position. Equally, if the defendant admits liability in full or in part, but disputes the causation of the injuries, then the claim will still remain within the protocol. Moving on then to quantum, some more time limits to be aware of. So once the claimant provides all the information they're required to in respect of their losses, so that's a fixed cost medical report, any additional medical reports if that's relevant, a list of the losses claimed and documents in support of those losses, the compensator must make an offer to settle the claim within 20 days, unless their position is that the accident did not cause any injury or that they now consider the value is over the prescribed limits. If the claimant has provided documentation in relation to some of the losses claimed, but not all of them, then an offer must still be made within 20 days relating to those heads of loss that have been evidenced by the claimant. So the fact that it's not fully evidenced does not mean that a response is not required. All offers made remain open for acceptance for 10 days. After that 10-day period has passed, the offer can be withdrawn, but until the offer is withdrawn, it is capable of being accepted by the other party, even if it has been rejected. So there's a facility on the portal that allows parties click a button saying accept a rejected offer. So a party can reject an offer and then later accept it. Once that offer has been accepted, it must be paid within 10 days. Unless there is not a certificate of recoverable benefits or one that would still be in force at the end of that 10-day period, in which case the compensator should apply for that certificate and pay the sum agreed within 30 days. Where the compensator chose that 4th option in respect of liability, so they accept fault for the accident in full or in part, but they dispute that the accident caused any injury, they must, within 20 days of receiving the information from the claimant in respect of their losses, notify the claimant that they continue to dispute that the accident caused that injury. If they do not, then the claim is treated as one where there has been admission of liability in full or in part. The dispute that the compensator raises in respect of causation is one which is sent to the medical expert, who will be specifically asked to comment on that within their report. Any offers to settle must include a breakdown of the offer. So that should include the fixed tariff amount for any whiplash injury, damages for any non-whiplash injuries, and the offer for each of the protocol damages, alongside an explanation about why any item is disputed, if it is. At the same time as any offer to settle on damages, the compensator must also make an offer on fees. So as with liability, each party can make up to 3 offers within the portal, and all of those offers require a statement of truth. And again, neither party can make a worse offer than their previous position. In cases where there has been a whiplash injury, no offers can be made and no payment can be paid or accepted until the claimant has first disclosed a medical report. In non-whiplash injury cases, offers can be made before a medical report is sent, but they would have to be made outside of the portal, and the protocol is very clear in listing the risks of doing this. Finally, where no offer is made within that 20-day period, the claimant may start court proceedings, but they have to wait for at least 20 days after sending that information that I went through earlier. So that's the importance of the time limit in terms of quantum, that if 20 days passes without an offer from the compensator, the claimant may start court proceedings. So that's a whistle-stop tour through some of the key points about small claims and the new RTA protocol. Thank you very much for listening.